start us off by really locating the issues we're discussing today within the context of the right to information as an internationally recognized right. After Advocate Weapon, you will hear from Mr. Nemasisi, who is the executive responsible for the Promotion of Access to Information Act within the Information Regulator. He will take us through some of the key obligations that PAIA, as we usually abbreviate the Promotion of Access to Information Act, some of the obligations that public bodies and private bodies have in terms of ensuring compliance with the law. We will try, colleagues, to make it as interactive as possible. And to this extent, we are live streaming on Facebook. And so those joining us via social media are free to pose questions to the panel. Those of you that are joining us via the Zoom platform, you'll be given an opportunity to also ask questions on the chat box, but also we will open it up for people to speak directly to the panelists. Hopefully we'll have a very interactive interaction. We don't want this to be some kind of lecture, but we want it to be a dialogue between ourselves, looking at the specific aspect of what it's public law, really, but it's a very narrow, very specific element within the bigger umbrella of public and administrative law. So without further ado, colleagues, let me hand you over to Advocate Colin Weapon, who is a member of the Information Regulator, for his opening remarks. Advocate Weapon.
Good afternoon, Mr. Dimba, and thank you so much for the opportunity. I'd also like to thank all the participants who've set time aside to actually attend this webinar. I'd also like to acknowledge Mr. Nemasisi for his attendance and presentation that he's going to do, as well as all the members of staff, including Ms. Zondi, who has also assisted greatly to ensure that the webinar takes place. I think every one of us knows by now that there is a law which has a constitutional aspect in terms of Section 32 of the Constitution. The law which refers to the promotion of access to information has been provided a means and a mechanism through legislation, and this legislation is now known as the Promotion of Access to Information Act. We also know that, and we also acknowledge, the work that the South African Human Rights Commission has done to assist in facilitating and administering access to information. But we all know and appreciate the fact that from the 1st of July 2021, there was a shift and there was a conversion of this specific right from and actually a transfer from the South African Human Rights Commission to the Information Regulator. And the Information Regulator as such has not actually discarded, but considered and is actively building on this work that the South African Human Rights Commission has done as far as it relates to the promotion of access to information. We also know that the 5-year term of the previous 5 members of the Information Regulator ended on the 30th of November 2021. From the 1st of December 2021, a new term was extended or provided to the following members: the chairperson, Advocate Pensi Tlakula, Advocate Struom as the designee for the for the promotion of access to information, Advocate Weapon, myself actually, as a designee for the protection of personal information, as well as Mr. Kwala, who will be joining the Information Regulator as part of the 4 members. Ms. Tully is the current member who has joined the Information Regulator from the 1st of December 2020, and she has currently served 1 year of a 5-year term. What is also very important, and what the Information Regulator considered very befitting and actually within the context of the developments in the country, is the fact that we know this right is globally celebrated today, but what is also very important, the theme for today, laying the foundation for the new era of PAIA implementation, was carefully selected. And what informs this selection when referring to factors in the context of our country is what we would call the judgment in the matter of Arena Holdings Pty Ltd, trading as Financial Mail and others, versus the South African Revenue Service. In this specific matter, the court found that, and in this specific context, that the right to access to information would trump the right to the protection of personal information based on public interest and all other factors that was described. What is also very important to appreciate is the judgment in the matter or the case of My Vote Counts. And that specific case has resulted in certain sections of PAIA to be amended. What is also very important for us to appreciate is that the right of promotion of access to information does not function in isolation, but it actually is functioning, and it is actually very well acknowledged in the Protection of Personal Information Act 4 of 2013, specifically Section 2, which refers to the purpose of the Act, and specifically so, Section 1, with reference to 1A, Roman figure 1, which states that balancing the right to privacy against other rights, particularly the right of access to information, as well as protecting important interests, including the free flow of information within the Republic and across international borders. And we also see Section 23 of the Protection of Personal Information Act, POPIA in short, also refers to access to personal information, specifically Section 23(1), 2, 3, 4, and 5 specifically makes reference to PAIA and also how the access should be facilitated and how the protection of, or the provisions of the Protection of Personal Information Act would be applicable. In saying all of this, we also acknowledge the close connection between the international theme on human rights, which reads as focusing on how the rights are beginning of pace within societies and a way to create a fairer society for future generations. And our theme connects and can be related to the international theme. What is also very important for us is that one of the objectives of this specific webinar amongst the many is to raise awareness amongst citizens about PAIA as an instrument to exercise and protect the rights to access to information. In saying all of this, we are also very mindful of the changing landscape which is brought about by the fourth industrial revolution, and specifically so, how these social media platforms would also impact on the right to access to information, but particularly so, how we should ensure that when we use all these aspects of the 4IR, that we are mindful of the consequences and the implications, particularly as it relates to access to information. I would also like to state that it is befitting at this stage, since the new members have taken office from the 1st of December, that this changing era will be looked at with a careful consideration of how access to information is applied in South Africa, but also the efficiencies around complaints, and also the education aspect, particularly how PAIA provides for awareness amongst previously disadvantaged groups. And this aspect remains a concern, not only for the regulator, but also at the level of the Portfolio Committee and Parliament. And we have been asked as the information regulator to provide a means to ensure that previously disadvantaged groups receive the necessary awareness and also has access to the information regulator. But key amongst all of these aspects is also, in a COVID context, how do we realize this, and how do we ensure that the disadvantaged groupings in South Africa are not further disadvantaged, even in a context of COVID. And lastly, it's also very befitting to state that the information regulator has acquired staff, and we now have a staff complement in excess of 81. And these employees are providing the necessary services which relates to the protection of personal information as well as the promotion of access to information. And our offices, despite the limitations of COVID, remains functional, and there are, for those who require assistance, to a certain extent, the necessary assistance so that the right of access to information can be realized amongst the South African citizens and the Greater Republic. Thank you so much, Mr. Dimba. I'm going to stop there and hand over to you.
Thank you so much, Advocate Weapon. In your presentation, Advocate Weapon, you describe what you call a changing landscape of PAIA. Some of this change is being brought about by the emerging case law on the Access to Information Act. And I believe that if some among us here have been working in PAIA for the last 20 years, like I have, you will not recognize PAIA and how it works today, because so much has changed in how we perceive the right itself, the right of access to information, but also how we interpret PAIA, which gives effect to the right. And so we need people among us who will be able to help us navigate this changing landscape. And it is my honor to present to you all today somebody who is one of the lead architects in this reconstruction of PAIA. Mr. Namasisi and his team are at the coalface of the many changes that are taking place in the PAIA landscape as described by Advocate Weapon. So without further ado, let me hand over to Mr. Namasisi to take us through the many changes that have occurred over the last few years on PAIA. Mr. Namasisi.
Thank you so much, Mr. Dimba, and good afternoon to Member Weapon, and good afternoon to everyone and colleagues. Thank you so much, Mr. Dimba. I think our presentation will not be that long. I don't have enough time. I'm not sure whether it's me who's sharing or somebody else is sharing. Try to move the slide, it's not moving.
Are you trying to move with your mouse, Mr. Namasisi?
With all the buttons, like enter.
With the arrow keys. Okay.
Yeah, with the arrow keys also it's not moving.
On your touchpad, if you use your touchpad right towards the bottom of your presentation by the logo.
Oh, there we go.
There will be some buttons that you can use there to move it forward and backwards.
Okay, there we go. That's good.
Okay, good.
Thank you so much. So the presentation will be made of the following topics. I'm going to touch on the introduction, just provide a brief background of the legislation, where it's coming from. I'll deal with the provisions as to how this legislation, the promotion of access to information, is applicable to which processing. We'll also deal in summary with the objects of the promotion of access to information. The major one is the key measures to ensure compliance with the promotion of access to information. This was the detail with that. We also deal with the issue of availability of the PAIA guides, which we are also available on our website. I'll deal with the access to records of public or private bodies. We'll also deal with the grounds of refusal of access to records. And we'll also deal with the process for lodging a complaint with the information regulator. What powers do we have as the regulator when we're investigating those complaints regarding the access to information? And what happened after you are not happy with the decision of the regulator? What do you do? We'll deal with the review of the decision of the regulator. We're also going to deal with the monitoring of compliance with the provision of PAIA. This is where we're going to deal with the issue of Section 32 and Section 83, subsection 4. What are the offenses and penalties which can be imposed for non-compliance with the provision of PAIA? And then we'll conclude our presentation. So the way of introduction, so the Constitution of the Republic of South Africa states that South Africa is a sovereign and democratic state that is founded on the advancement of human rights and an accountable, responsive, transparent system of governance as part of its values. And then South Africa became the constitutional democracy with an enforceable Bill of Rights. The system of government in South Africa, amongst others, resulted in secretive and unresponsive culture in both public and private bodies, which often led to the abuse of power and human rights violation. In this regard, it is in this regard that the Constitution in Section 32(1) of the Bill of Rights provide for the right of access to information held by the state, which state include public bodies, and any information held by another person that is required for the exercise or protection of any rights. The requirement relating to the protection of rights is confined to the information held in the private hands. In other words, private bodies are thus subjected to a less stringent standard of transparency than the public body. The private sector, in other words, is entitled to keep its information to itself unless that information is needed for the purpose of exercising or protection of any rights. In other words, if you want to request access to information from the private body, you must indicate the rights that you want to exercise or you intend to protect. In the absence of those rights, you are not entitled to the information. But if you request information from the public body, you do not necessarily have to prove any rights. Section 32(2) of the Constitution in turn provides for the enactment of national legislation that will give effect to this right of access to information, with this right of by respecting, protecting, promoting, and fulfillment of the right of access to information. The promotion of access to information, which popularly known as PAIA, has been amended by POPIA, is the national legislation which was enacted in accordance with the above mentioned Section 32 of the Constitution. If you look at its preamble, PAIA acknowledges the secretive and unresponsive culture of the pre-democratic era. So offering any person access to state-held information is one of the most effective ways of upholding the constitutional value. And these values are transparency, openness, participation, and accountability. So the above mentioned constitutional values cannot be attained if government has a monopoly of the information that informs its action and decision. Therefore, access to information is not only fundamental to a properly functioning participatory democracy, but it also increases public confidence in government and enhances its legitimacy. So this promotion of access to information, who does it apply? So PAIA applies to the record of public body and private body, regardless of when the record came into existence. Unlike other countries in which this piece of legislation is only applicable to the public body, in South Africa, it's applicable to both public and private bodies. And records in possession or under the control of an official of public body or private body in his or her capacity as such, or an independent contractor engaged by a public or private body in such capacity as a contractor is regarded as being a record of a public or private body. Just to give a practical example, if the information regulator appoint a service provider to provide services on behalf of the regulator. And they then develop, they've got certain information. So that information which they have, which they obtain as a result of them rendering services on behalf of the regulator, such information they have belongs to the regulator and therefore will be regarded as a public body information. So PAIA takes precedent over any provision of other legislation that prohibits or restricts the disclosure of a record of public or private body and which is materially inconsistent with an object or a specific provision of PAIA. Obviously, there are certain pieces of legislation that provide for access to information. So insofar as there is materially inconsistent, PAIA will take precedent. But in general, those other legislation will actually be applicable unless they are materially inconsistent with the objects of the PAIA. So the PAIA does not apply obviously to record of public or private body if that record is required for the purpose of criminal or civil proceedings, so requested after the commencement of criminal or civil proceedings and the production or access to that records for the purpose of criminal or civil proceeding is provided for in any other law. For example, if you are in court and there's a court processes, you'll find that the court rules and legislation provide for how you can access the information relating to the matter that's before court. So in that instance, PAIA will not be applicable and the rules regarding those court process will be the one taking precedent with regard to that process in that court. PAIA does not apply also to the record of a cabinet and its committee. In other words, with regard to the cabinet decisions, you may not necessarily use the PAIA requirement in order to access those information. It also does not apply to the record relating to the judicial function of a court or special tribunal units, the SIU tribunal or judicial officer of such court. It also does not apply to an individual member of parliament or a provincial legislature in that capacity. PAIA does not apply to a record relating to a decision regarding the nomination, selection, or appointment of a judicial officer or any other person by the Judicial Service Commission. What are the objects of this piece of legislation? So the main objects of PAIA are to give effect to the constitutional right of access to any information held by the state and any information that is held by another person and that is required for the exercise or protection of any rights. And it also, its object is to give effect to the constitutional right of access to any information in a manner which balances the right of access to any information with other rights, including the rights contained in the Bill of Rights. Remember, we want to give an example of the recent judgment in the High Court, wherein the court has ordered the South African Revenue Services to release certain personal information. In that instance, as Member Wipon has indicated, the court balanced the two rights, rights of access to information and the rights to protection of personal information. Lastly, it also, its object is to promote transparency, as I indicated earlier on, accountability and effective governance in all public and private bodies by empowering and educating everyone to exercise their rights in relation to public and private bodies and effectively scrutinize the processes of those bodies. It also obviously educating everyone to participate in decision-making by public bodies that affects their rights. What is very important now is to notice that the right of access to any information, it's a very powerful constitutional right, as it helps anyone to realize any other rights. You know, as I'm preparing for this presentation, I was thinking of any instances in which anyone can access the rights, any other rights without firstly exercising the right of access to information. If you want to invoke any of the Bill of Rights, you need to have information first before you can invoke all of them. And that's why this right of access to information is the most important right, because any other rights that you exercise, you can only exercise them when you've got the relevant information that you want. And how do you get that information? Through these rights to access to information. One of the key measures, what are the key measures that public and private bodies must have to ensure compliance with the promotion of access to information? As you know that we have taken over the function of, and we are regulating this piece of legislation. So it is important that public and private bodies become aware of what is it that they should do in order to ensure that they comply with legislation, because non-compliance, as you'll see later on, can result in criminal action being taken or enforcement notice issued by the regulator. So in this topic, I'm going to deal with the issue of PAIA manual, availability of those PAIA manual, the most critical one, exemption from compiling the PAIA manual, and I'll also deal quickly with the delegation or designation of deputy information officers. So with regard to the manual, the information office of a public body, these are, for example, your CEOs of a public body, are required in terms of Section 14 of PAIA to compile a PAIA manual in at least 3 official languages. And the head of private body is also required to make a PAIA manual available, but there is no requirement of 3 languages, and it must be at least in English as the official communicating language. So in other words, if you're a public body, you need to have a PAIA manual, but that PAIA manual must be in at least 3 official languages. If you're a private body, there is no requirement of having it more than 1 language, but it does not mean that if you want to have a manual in more than 1 language, you cannot do so. But there is no legislative requirement to have it in more than 1 language. But at least you must have, as a private body, the PAIA manual in at least in English. Please note that Section 14 and 51 of PAIA has been amended. This amendment came about by the Section 110 of PAIA. And this amendment came into effect on the 30th of June 2021. And the PAIA manual, in terms of this amendment, the PAIA manual must include information relating to the processing of personal information, such as the purpose of processing personal information, the recipient or category of recipient to whom the personal information may be supplied, as well as it also requires you to specify what security measures you have insofar as those personal information is being processed by that particular body. So those amendment of PAIA manual now require those private bodies and public bodies who had the manual before the 30th of June to ensure that their manual is now revised to be in compliance with the amendments that has came into operation on the 30th of June 2021. Then the issue of how do you make those PAIA manual available? Unlike in the past where when a PAIA manual is prepared, you need to submit those manuals to the Human Rights Commission. Now that the information regulator has taken over that function of PAIA, then the amendment therefore does not require a public or private body to submit their manual to the information regulator. All you need to do once you have compiled that PAIA manual, you need to have that PAIA manual available on the website. So each and every public or private body who has the website, they need to ensure that the PAIA manual is available on their website. If you don't have a website, then it means you need to have the PAIA manual at the head office, which should be available for inspection during normal business hours. Even the company which has a website, they also need to have hard copies of those PAIA manual for inspection in case other people may not have access to the internet. If they want to access your personal, to know what kind of information you have or they can access, they should be able to come to the office and have access to the manual and be able to understand what information they can request access to. You also have to make sure that the manual you make available to anyone upon request, but obviously you can charge payment for making that PAIA manual available upon request. But mostly it's if you request a hard copy. But if, for example, they're just sending an email, you may not necessarily have to charge them. But if they want copies to be made for them, you can charge for making copies. And the fees are prescribed in the regulation, which regulations are available in our website. It's Annexure B to the regulation. You can check how much you can charge for making your PAIA manual available. Also, the regulator can request a copy of the manual. And if the regulator requests a copy, you need to provide a copy to the regulator. And this is part of our mandate to ensure, as we conduct compliance assessment, we may request for a copy of the PAIA manual. So those are the 4 instances in which the PAIA manual must be made available by both public and private bodies. And there's an issue about the exemption from compiling PAIA manual. As you know, in the past 10, 20 years, the Minister of Justice have been exempting certain private bodies from compiling PAIA manual. And this was done in terms of Section 51.4. But however, Section 14.5 as well of PAIA does provide the minister with powers to exempt any category of public or private bodies from compiling manual. But the minister has never exercised that right under Section 14.5. In other words, public bodies have never been exempted from compiling manual, but certain private bodies were exempted from compiling manual. Since the promulgation of PAIA, only certain categories of private bodies were exempted from the requirement to compile manual and make the PAIA manual available. And those people are even currently, they're still exempted. The main reason for granting the past and current exemption was that the South African Human Rights Commission did not have capacity to store all the manual that is it was made required to receive into its custody. You remember earlier on I indicated that in the past, when you compile your manual, you have to submit a copy to the South African Human Rights Commission. You can imagine how many public bodies and how many private companies we have. And if there was no exemption, millions and millions of those manuals will have to be submitted to the Human Rights Commission. And it didn't have enough storage to safeguard those manuals. Hence, the amendment now, it does not require any submission of those manuals to the information regulator. So the regulator is the custodian of PAIA, as I indicated earlier on, who took over the power to regulate this piece of legislation on 30th of June, has reconsidered the significance of the legislative requirement for compiling PAIA manual, especially the amendment of section 51 of PAIA, in terms of which the requirement of submission of PAIA manual to the regulator has been repealed or does not exist anymore. In other words, there is no requirement to submit PAIA manual. We also consider the scope of the information that the manual must cover has been now widened. That scope has been widened. I indicated earlier on that we now include the information related to the protection of personal information, where you need to specify what kind of security measures you have, whether you're going to transfer information outside the country, and if so, which country, whether what kind of personal information you process, and what is the purpose of processing those personal information. The PAIA manual must include those information. And as a result, we look at those amendments, and having considered those amendments and the fact that the reason that forms the basis of the past and current exemption will no longer be applicable, the regulator has decided that there is no legal basis to further extend the current exemption of certain private bodies from compiling and making a PAIA manual. What does that mean now? It means that the current exemption, which will lapse on the 31st of December 2021, it means that from the 1st of January 2022, every public and private bodies must have a PAIA manual and ensure that such manual is available, as mentioned earlier on, in their website, at their head office, upon request and by the regulator, and upon request by any person who wants to access those information. So from the 1st of January 2022, public and private bodies are required to have their PAIA manual available. What we did as the regulator to assist the public and private bodies to compile this manual, especially after the amendment of section 14 and 51 of PAIA, insofar as what manual should contain. We then developed the PAIA manual template. This is a very user-friendly template that we've developed. It is available in our new website. We have got a new website that we have, and we have uploaded those templates of PAIA manual. There is, if you look at those templates of PAIA manual, you see that there's an explanatory note that we have. In each category where you need to populate, you'll see there's explanation as to what kind of information you need to have. So it's a user-friendly that you may not necessarily have to go and get a lawyer to compile those PAIA manual, because every aspect that needs to be populated, there's an explanation as to what kind of information. Just to give a practical example, if you're supposed to indicate the personal information that you process, you indicate that you do have a qualification of the employees that you have. You do have, obviously, the medical information of the employees, because when employees go on sick leave, they submit leave forms and a medical certificate that they're sick. So those are the personal information that you also specify in your PAIA manual. So, but those templates provide an example and practical example on what information should be loaded on those PAIA manual. Once you populated everything, then your PAIA manual will be ready. There's an issue about the designation delegation of deputy information officers. As an information officer of each public and private body, like CEOs, those are the most busy people. And therefore, you may need to have a deputy information officer. This is the person who's going to assist you when there's a request for access to information. And because if you don't respond to certain things, or you don't do certain things under PAIA, there's a criminal sanction, as I will indicate later on, what kind of sanction that you may have as an information officer. So we encourage both CEO of public body or private bodies to designate or delegate certain power to the deputy information officers. And normally a deputy information officer will be any person who's a senior level who will be assist the information officer in carrying out his or her obligation. So if you look at section 17 of PAIA, it regulates the designation and delegation of deputy information officer. That's the information officer of a public body. But then if you read section 56 of PAIA, it then extends those obligations to now private bodies that they must designate and delegate such number of persons as deputy information officer. You do not necessarily have to appoint one person. If you're a big corporation, a big entity, you can appoint more than one. If you've got a national footprint, in other words, you've got offices in each provinces, you can appoint a deputy information officer or delegate certain power to a deputy information officer in each provincial offices. But that's the discretion of the information officer as to how many deputy information officers they may want. And also one of the issues that you look at is the number of the requests that you are receiving as a body, and that will determine the number of people that you can designate as deputy information officer. The designation has to be formal, and as a result, when we develop a guidance note on information officer and deputy information officer, which guidance note is available on our new website, you'll see at the last page of those, there's a template of the designation and delegation of authority to the information officer. Those templates are the ones that you need to officially designate or delegate those deputy information officer. When we conduct compliance assessment, those are the issues that we're going to look at as to if you've got deputy information officer, we'll check whether you have officially delegated those people, or because it cannot be done by verbally. There's a requirement of the regulator to also make the PAIA guide. This is the guide in which we need to simplify the legislation, the PAIA. Give practical example. One of the questions that I see on the platform was whether there's a case law that we're going to share. If you look at the guide, there are certain case law that we've cited as well in the guide, but it actually explains in detail how you can access your the information from any public or private body. So the regulator did compile this guide in terms of section 10, with regulation 2 of the PAIA regulation. And this guide is in all official languages. It means 11 official languages. We also made this guide available also in Braille. It is available in our website. So all guides, PAIA guides are available in our website. They provide extensive explanation of each aspect, which process should be followed. So it's provide a guide on how you can access the information regulator, how you can access information. And we encourage everybody to go to our new website and check those guides, which are available in all official languages. We indicated that we also did not only do the guide in Braille, although in official languages, we also did this guide in Braille. Unfortunately, because it's Braille, we cannot upload in the website, but copies are available at our office. For those who want to access the guides in Braille, they can actually come to our offices. You can make a copy available. You can also, for inspection, those copies are available at our offices. Even the actual guides, those who may not be able to access their website, they can actually come to our offices for inspection. They can inspect those guides as well in our offices. The information office of a public body, in terms of regulation 3.1, are actually required to have a copy of the guide, which obviously they can download those copies from our website in at least 2 of the official languages. In other words, if you are a CEO of the public body, you need to then have at least 2 copies of those guides in different languages available in your offices, at the registered office for public inspection. So that's a requirement that the CEO of each public body must make sure that there's a guide, a PAIA guide in at least 2 official languages. The information officer of public body is further required in terms of regulation 3.2 to make available the number of copies of the guide in the official languages as requested on Form 1. So in other words, if you want access to the PAIA guide, you don't necessarily have to come to the regulator. You can actually go to any public office and request them for a copy of the guide, and they are required to give you a copy of that guide. We have provided a link to those guides, to the Form 1 in which you can use when you want to request the copy of the guide. So you can go to any public office and you ask them to provide you a copy of the guide. They are required to give you access to that copy of that guide. And let's deal with the issue of access to records of a public and private body. What process do you have to follow in order to acquire access to the records? So if you look at section 11.1 and 51 of PAIA, it makes it an obligation for information officer or head of private body to grant access to the record. If, for example, firstly, the requester complies with the procedure requirement. In other words, if you complete Form 2, which is the PAIA request form, you complete that form, then the public and private body must give you access. But also, if the record that you are requesting access to does not fall under any of the grounds of refusal, there are grounds of refusal, as we indicate later on, that the public and private body can rely on. And these are the grounds that the South African Revenue Service SARS rely on when they refuse access to the personal tax information of the former president. They rely in one of those grounds. So over and above the requirements stipulated in section 11.1, the head of private body must grant access to the record only if the said records are required for the exercise or protection of any right. So there are 3 requirements that need to be complied with in order for the public and private body to give you access to their records. Firstly, you need to complete the PAIA request form, submit it. They've got 30 days to reply. And also, the information that you require should not fall under any grounds of refusal. And lastly, you can only be granted access to the information if that information from the private body is required for the exercising or protection of any rights. Unlike in the past, wherein there were 2 different PAIA request forms for access to information, a request for access to records of public and private body must be made in Form 2, and that form must be addressed to the information officer or the head of a private body. Like, for example, in the past, we used to have Form B and Form C. So if you want to access the information public body, you have to fill a specific form, which was designated for that specific body. Now, we only have one form, which is applicable to the public and private body. And this PAIA request form is also available at our website. It's our new website wherein the public and private bodies can actually access those PAIA request forms, and they can request access to the bodies that they would like to require to access their information. So with regard to the access to the records of the body, the information officer or his or her delegated information officer has an obligation to render such reasonable assistance free of charge to any individual who, due to illiteracy or disabilities, unable to complete Form 2 by reducing the oral request to writing in the prescribed form and provide a copy thereof to the requester. So in other words, if, for example, you want to access information of the regulator and you are unable to fill the form because of illiteracy or because of disability, you can actually call our office, and our people, our colleagues will be able to assist you to complete that file, that complaint, that PAIA request form. They'll give you a copy and then they'll process your request. And this can all be done in all public bodies. The decision on the request for access to records must be made as soon as reasonable possible, but should be made within 30 days. These 30 days can be extended, but cannot be extended for more than 30 days. You can extend, and you can only extend it if, for example, the information that's required, you need to go and check it somewhere else where it's not readily available, need to be sought somewhere else. That's where you can extend the 30 days. But the requirement is that a decision on your request for access must be made within 30 days. And if the request, obviously, once you submit your request for access, the body has got grounds upon which they can rely on to refuse you access. So when a request for access to a record is made, a body may grant a request and give access to the record. However, PAIA provides a list of reasons or ground why a request may or must be refused. And this is important, as a request for access can only be refused on the basis of any of those listed grounds for refusal of access to records. So if you go to the promotion of access to information, you'll see there are grounds for refusal of access to information. Those are the only grounds upon which the public or private bodies can refuse you access, can rely on when they refuse you access. They cannot refuse you access on any other grounds except what is contained in that legislation. But despite the above mentioned grounds for refusal of access to records, the information officer or head of private body must, in accordance with section 46 and Section 70 of PAIA grant a request for access to a record of a body if the disclosure of the record will reveal evidence of substantial contravention or failure to comply with the law or an imminent or serious public safety or environmental risk, and the public interest in the disclosure of the record clearly outweigh the harm contemplated in the listed grounds of refusal. This is exactly what the recent case law between the media company and SARS, that court used this section 46 and 70 in interpreting whether the rights of access to information outweigh the rights of protection of personal information. And that's what the court found, that the rights of access to information in the public interest outweigh to a substantial degree the rights to protection of personal information. Hence, the personal information of the former president were ordered to release. However, that judgment is subject to an appeal. So we are actually monitoring that judgment. And this is the judgment which has given that the balancing effect between the right of access to information and the right of protection of personal information. This judgment is actually subject to appeal. As the regulator, we are part of the proceedings. We are monitoring those processes, and because the outcome of this judgment will actually provide jurisprudence on how the regulator, because you see the regulator perform dual mandate in terms of protection of personal information and promotion of access to information. So this judgment will actually go into exactly how we can regulate our the promotion of access to information. We now deal with the process for lodging a complaint with the regulator. Now that if your information, your request for access to information has been refused, what process do you do? So lodging a complaint with the regulator is not a prerequisite for approaching the court. So in other words, as a requester, you've got two options when your refusal of access to information, when a decision has been taken to refuse you access to any information. You can either come to the regulator and lodge a complaint, or you can actually go straight to the court. You do not necessarily have to come to the regulator before you go to court. So if you've got an option whether to come to the regulator or you go to court. Obviously, due to the efficiencies of the regulator, you may want to use the regulator, because there is no cost involved when approaching the regulator for the regulator to assist you in exercising your rights of access to information. So this means that one may approach the court as soon as internal remedies are exhausted, or as soon as his or her request for access to the record is refused. So there are two options that you can exercise. You can either come to the regulator or go to the regulator. So if you decided to come to the regulator, a complaint to the regulator must be made in writing. You have to use complete Form 5. And this form is also available in our new website, which is now, you can see on a spreadsheet. We are indicating that website that you can visit and you'll be able to download Form 5. This is a very user-friendly form that it's a PDF, but it's fillable. So there will not be an issue that one of our colleagues will be calling you to say, we cannot see your handwriting. If you have a laptop, you download this form, you can actually fill this form, even that PDF, you can fill on this form and just submit to the regulator as it is. The regulator will provide reasonable assistance to enable a person who wishes to make a complaint to put a complaint in writing. So we do have an obligation as well when you want to lodge a complaint to the regulator to provide an assistance in completing that form. So a requester or a third party aggrieved by the decision of the information officer or a head of private body must lodge his or her or its complaint with the regulator within 180 days of receipt of the decision. So in other words, if you submitted your PAIA request, the private or public body decided to refuse access to those records that you wanted, you've got 180 days to come to the regulator to lodge a complaint. If the complaint is lodged outside the prescribed 180 days, a condonation application must accompany the complaint form, indicating the reasons for the delay. Obviously, the degree of lateness, amongst others, will be some of the issues that we're going to consider in determining the condonation application. But we encourage everyone that as soon as you receive a decision and you're not happy with that decision of the public or private bodies, insofar as your right of access to information is concerned, please come to the regulator within that time so that you don't have to deal with the issue of condonation. Upon the receipt of that application, if it's, we have granted condonation or it's lodged within 180 days, the regulator has got 20 days within which to decide whether to accept a complaint or reject a complaint. And the turnaround time frames for completing an investigation it ranges from 3 to 12 months. These are turnaround, but as it is now, the 20 days in which we're supposed to take a decision, it's when we conduct what we call a pre-investigation. It's an initial assessment to check whether your complaint has got merit or not. And if we feel that your complaint has got merit, then we'll decide to refer it to a full investigation, or we can actually refer it to a settlement process, because we do have the power to resolve complaints through the ADR processes. In other words, we can negotiate with the public and private bodies to assist you to get access to those information. If settlement negotiations fail, then that's where we can go and deal with the full investigation in which we can exercise our powers. So the question is, what powers do we have as the regulator when we conduct an investigation? Unlike the Human Rights Commission, which did not have power, we've got a very, very strong powers, similar to the one of Zondo Commission, if we were to give a practical example. So we can issue a summons or subpoena a person or any document. When we conduct an investigation, we can issue a summons to any person to come and appear before the regulator. We can subpoena any documents. And if you fail to do so, you know what happened at the Zondo Commission. That's similar power that we have. If you fail to comply with the subpoena or the summons that we issue, obviously that's a criminal conduct, and obviously you end up in prison. We also have the power to issue an information notice. The information notice is the notice in terms of which will require you to submit certain information. And that notice must be complied with. We also have the power to issue an information notice, enforcement notice. An enforcement notice is equivalent to the court order. So if we issue an enforcement notice, you don't comply with the enforcement notice, it's a contempt of the regulator, and therefore it's a criminal action. You'll see later on when we deal with the sanction, what will be the fine or the sentence that you may have to serve in prison for not compliance with the enforcement notice. Why do I say the enforcement notice is similar to the court order? If you don't comply with the court order, same thing. It's a contempt of the court, and then you will have to go to prison. You can be sent to prison for non-compliance with the enforcement notice. So the regulator, upon finalizing an investigation, will then issue an enforcement notice. The enforcement notice will be issuing an order directing a private or public body to do certain things. If they refuse to access, we can direct them to release those documents. And if they do not give you that, comply with enforcement power, will indicate to you later on as to what would be the sanction to that information officer who doesn't comply with the powers of with the order of the regulator. We also, as I indicated earlier on, have got power to resolve dispute through settlement or conciliation. If the matters refer to conciliation or settlement, we issue a settlement certificate if the matter is settled. And that certificate is the one that obviously needs to be complied with. If it's not complied with, we then convert that certificate into an enforcement notice, which you have to comply with. And the question is, what if the regulator issued the decision? Let's say you're a public or private body, and the regulator issued a decision and you're not happy with the decision, or you are the requester, you lodge a complaint to the regulator, you're not happy with the decision of the regulator. What do? You actually can review our decision to court. As I indicated earlier, the regulator is an independent body. We're not accountable to a political head, any minister. We're accountable to parliament. So it means there is no political solution with regard to our decision. Our decision can only be set aside by the court. So once we take a decision, you cannot go to any person and say, please assist us. No one can actually interfere in the function of the regulator because we're independent. We're only subject to the constitution and the law, and our decision can only be reviewed in court. So in other words, the decision of the regulator is binding on any person, and any person aggrieved by the decision of the regulator can take that decision on review before the competent court. So this right is available to both the private body, public body, or even the person who lodged a complaint. If they're not happy with the decision of the regulator, they can actually go to court and request the court to set aside that decision. Please note that making an application for review does not automatically suspend the decision of the regulator, unless the enforcement notice is suspended by the court pending the adjudication of the review application. Because we're independent, subject to the constitution and the law, when you go to review our decision, the filing of the review application does not automatically suspend. So what normally happens is that when you file your application, you need to then automatically request the court to suspend the enforcement notice. So you'll have Part A and Part B. Part A will be held on an urgent basis to suspend the enforcement notice pending the determination of Part B of the application for review. We also conduct the monitoring of compliance with the provision of PAIA. How do we do so? As part of the regulator mandate to monitor compliance with the provision of PAIA, and so far as the request of access to information is concerned, the Information Officer of Public Body is required in terms of Section 32 of PAIA to submit its annual statistics on how requests for access have been attended to. And this includes, so those statistics will have to be submitted to the regulator, wherein the public body will indicate the number of requests of access that they've received. They'll also, in that statistics, indicate the number of requests which has been granted, number of requests refused, number of internal appeals that has been granted, and number of applications which has been lodged to court. In other words, instances wherein request for access has been refused and the person decided to go to court. Those statistics must be submitted to the regulator by public body. The regulator is also empowered in terms of Section 83.4 to request the head of certain private bodies to furnish it with the same statistics. So we can actually request even private bodies to indicate the number of complaints that they've received and which they've refused or which they have been referred to the court. Currently, the regulator is in the process of developing a portal for the submission of those statistics about the request for access to records of public or private bodies. So this would be an online submission, unlike in the past where in the Human Rights Commission you have to fill in the form, which was not user-friendly. We are in the process of developing the system. So you just log in into the system where you then complete these statistics online, and then you submit it, and the system will be open for a certain period, wherein the public and private bodies can log in and submit those statistics to the regulator. This is a compulsory to everyone, but notification by our communication department will be issued when that system is live and when you're supposed to submit those statistics. So the development of portal will be completed before the end of this financial year, which means by the end of March 2022, we are hoping that the system will be ready, and the reporting starts from around May and June. This is where we're going to request public and private bodies to submit those statistics, but a further communication will be issued by our communication department. Earlier on, I indicated the powers which the regulator has insofar as the access to information is concerned. And those powers, it means if you don't comply with the decision of enforcement notice of the regulator, or if you don't comply with the legislation in general, what are the offenses and penalties? So the first one is, you find this in Section 90, subsection 1, where a person who, with the intent to deny a right of access to information, if you destroy, damage, or alter the record, if you conceal the record, or if you falsify the record or make false record, that is an offense, and upon conviction, you'll be liable to a fine or to imprisonment for a period not exceeding 2 years imprisonment for falsifying or concealing the record. So if, for example, you know that this body actually does have certain records, but they're actually alleging that they don't have those records, that's concealing the record. That is an offense. And if a criminal case is open, the information officer can actually be sent to prison for a period of 2 years in prison just for concealing records. You can see how important it is to comply with the promotion of access to information. Another offense that you have is when the information officer or head of private body who willfully or in a grossly negligent manner fails to compile a PAIA manual and make it available as prescribed. I indicated earlier on that from the 1st of January 2022, the public and private bodies are required to have their PAIA manual. There will be no exemption. No private body will be exempted from compiling manual. And if you fail and willfully fail to compile this PAIA manual, it is an offense, and upon conviction, you will be liable to a fine or to imprisonment for a period of 2 years. And this is a very simple 2 years just for failing to compile a PAIA manual when a template has been provided by the regulator on the website. So we encourage everyone to go into our website, start compiling this PAIA manual to avoid going to prison for a period of 2 years just for not compiling the PAIA manual. The last one, the last offense that is up, not the last actually. If you look at Section 77, I indicated earlier on that the regulator does have the power to issue an enforcement notice. And I said that enforcement notice is equivalent to a court order. And if you don't comply with the enforcement notice where we direct you, for example, to say you should have granted access to those records, and we direct you to issue to release those records to the person who requests access, and you decided not to comply with that enforcement notice, it's an offense, and the regulator can actually send you through the court process to prison for a period of 3 years imprisonment, just to fail to comply with the order of the regulator in the form of enforcement notice. The last one is the one in which the information officer who willfully or in a grossly negligent manner charges a fee other than the fee prescribed. I indicated earlier on that there are fees that are prescribed in our regulations, and if you charge higher fees than the one that is prescribed, it's an offense as well, because normally people will charge those fees in order to avoid releasing the records. So that is now an offense in terms of Regulation 16. And if you're found guilty, you'll be sent to prison for a period of 2 years. You see here that the years of imprisonment is very high. This only signifies the importance of compliance with this piece of legislation. So in conclusion, we want to report to the public as well that in accordance with Section 83.3 subsection A, Roman figure 2 of PAIA, the regulator has developed a procedure for making information electronically available. Remember, we want to talk about the 4IR. And you see, due to COVID-19 now, it will be difficult for anyone to have records, hard copies of the records. And now this procedure that we have developed, they are actually at the advanced stage, will be publicized very soon. This procedure will provide guidance on how to make information electronically available. In other words, if a request for access is provided, you don't have to go and print and give people hard copies, because during the COVID-19, chances that when you print the hard copies, you'll be transmitting the virus from one place to the other. So this procedure, we have developed this procedure in terms of Section 83. It will be made available to assist, obviously, people to make sure how do you make the information electronically available instead of giving the information through the hard copies. And that will streamline the accessibility of the information that may be required. You do not have to search for it, because to be electronically available, it's easy to retrieve information electronically than to go to a storage where you need to search. Lastly, we obviously, as the regulator, we want to ensure that we have got efficiencies in processing the complaints. Just to report, as I'm concluding, currently we have received about 27 complaints, and most of the complaints have now been investigated and will be referred to the enforcement committee, where we'll be directing those public and private bodies through this information. It is encouraging, Program Director, that most of the complaints that we have received are actually complaints against private bodies. In the past, you'll find that most of the requests for access to information is mostly against public bodies. Now we have seen the increase in the exercising of these rights of access to information against private bodies. And these are the trends that we have seen developing. Thank you so much, Program Director.
Thank you, Mr. Namasisi. Wow, that was excellent and well-timed. Colleagues, I'm not going to waste a lot of time by recapping, and there are so many exciting questions that you've put on the chat box that I would like to jump right into. I've noted a few questions that have been asked on the chat box, and I will lift some of those for a response by Mr. Namasisi and Advocate Weapon. Quite a number of the questions relate to the exemptions that are provided for in PAIA. My colleague, former colleague, Professor Richard Cullen from the University of Cape Town, uses the analogy of a block of Swiss cheese. You know, Swiss cheese is a full block of cheese, but there are holes in the cheese. So he says the right of access to information is that cheese, but the exemptions or the exceptions on accessing information are those holes on the block of cheese. Essentially, what this means is, like all other rights in our Bill of Rights, at least most of them, it is not an unlimited right. It will be unlimited by certain, it will be limited by certain circumstances. In PAIA, those are referred to as exemptions. PAIA has two types of exemptions. There are those that are called non-mandatory exemptions. Those are instances where an information officer may refuse access to a record. And there are mandatory exemptions, which are those where an information officer must refuse access to a record. Of course, they are all subject to a public interest override, which we can talk a bit more about later. Now, Mr. Namasisi and Advocate Weapon, the first two questions we got spoke exactly to this issue. The first one is on a mandatory exemption where Mr. Daniel Marais was asking, are legal opinions exempt before litigation has started? And you would know this would be section 40 of PAIA, which relates to records privileged from production in terms of legal proceedings. I would like Mr. Namasisi and Advocate Weapon to speak to that question first, and then we'll go to the next exemption that was asked about.
Thank you so much. Thank you, Mr. Dimba. Mr. Namasisi, if you're able to, can you handle the first two questions? Thank you.
Thank you, Member Kwana. Thanks for that comment, Program Director, regarding the mandatory and non-mandatory grounds of refusal, as we say in terms of PAIA, and those who also refer them as exemption. So indeed, if you look at section 40, obviously, it's a mandatory. It's a mandatory protection of records privileged from production in legal proceedings. So if you look at section 40, it says the information officer of public body must refuse requests for access to the records of a body if the record is privileged from production in legal proceeding, unless the person entitled to the privilege has waived that. So the obligation is placed to the person, the holder of the privilege. So if, for example, I've got a legal opinion or legal documents that I have, I'm the one who can waive them for anyone to say you are entitled to those information. So those are the most critical things that you need to look at. So just to emphasize as well, when you want to differentiate between the mandatory and non-mandatory, the legislature under the grounds of refusal, they use must and they use may. So that's how you differentiate between the two. Where they use must, it means it's a must, you must refuse. When they use may, there's a discretion by the information officer or head of private body, whether to grant or not to grant. But the most critical one, like we indicated, section 46, with regard to the access to the information of public body, insofar as the public interest override is concerned, and section 70, it's the same provision, but for some reason, they differentiate them in terms of section, but they provide for the same protection. Thank you, Member Upon.
Thank you, Mr. Namasisi. Let me give you the second one. Now, the second one, I think, relates to a non-mandatory exemption because Mr. Julian Kruger wants to know if PAIA applies to ex-code decisions. I would think that this would be section 44 on the operation of private bodies, where PAIA says the information officer may refuse access to information in those circumstances. What do you think?
Indeed, it's a discretionary. Obviously, there are certain things that you may not necessarily want to discuss. And I remember when we're developing our internal policy, internal access to information policy, one of the instances in which the EXCO decision may not be disclosed will be the deliberation leading to the decision. That you may not disclose. But the decision that we make may have to be disclosed. And I'll give a practical example. So as EXCO, as an executive under the information regulator, we take decisions that may impact on the rights of the public. So those decisions are the ones that if you want to access our info as to how did you reach, so if there's a decision that you're not happy with it, for example, let's say you request access to our information and EXCO through the CEO, we decided not to grant you access. Then you can actually challenge our decision. But the deliberation that results in that is something that may be privileged because you still want to encourage people to deliberate on the issue that you have. And that's the same as the information when the board sits. The deliberation by the board normally would be privileged. That's where you may decide not to issue the deliberation. But the final decision is the one that you have the rights to access them. So that one, you may not refuse access. So that's how normally you differentiate how to exercise your discretion. Thank you, Program Director.
So you're saying this would be what is called the deliberative process exemption, which is built into the process to allow public officials to receive advice, to receive opinions in order to formulate a decision? Is that how it works?
Because normally when you want access, you want to challenge the decision, not the processes or the deliberation of those people. Because if the deliberation then form part of what people are given access, then you're discouraging people to communicate their view. So in most instances, you will only want to challenge the decision, and that's what you need to then be provided with as the decision that you want to challenge. So this is not applicable in all instances. There are instances wherein you want to see that you may want to release even the deliberation, but that's a decision that will have to be taken by the person who has got the power to release the information as to which information it can be released, because you've got a discretion. The Act says you may release that information.
So,
thank you.
Mr. Nemasisi, I think you may have, I'm giving you one point. If we were playing a soccer match, I would say you're getting 1 point on that. That's one goal. But Helen Koshane is coming back very strong against you. She is asking, can a candidate who attended an interview request access to the documents or the score sheets of the other candidates? So how does this, what the answer you've just given us, how does this apply to this context that Ms. Kochane has just shared on the chat?
Remember, during my presentation, I referred to the constitutional values, and one of them is accountability, transparency as well. The score sheet may be disclosed because remember, you need to scrutinize the decision of the public body insofar as how did you arrive into the score wherein I did not make it. So those are the things that the issue of balancing the right of access to information and the right to protection of personal information. The score sheet may not necessarily be a personal information of the person if you were to interpret it, because this is the score of the person who is actually scoring. It is not that person who is scoring. The information, unless you then started to request the personal information of that person who was conducting interview, their CVs, their qualification, that's where the issue might be, because you'll be going into now the personal information. PAIA kicks in 8 conditions for protection of personal information. And that's where the issue of balancing effects is concerned. But if you want to scrutinize as to how did this person get appointed, obviously those information may have to be provided, especially if you want to exercise your rights, which is the rights for you to understand how you were not appointed. Because remember, there's an issue about fairness in any processes that take place. And how do you exercise your rights to ensure that you have been treated fairly without having access to the score that you have? But those will be obviously decided depending on the nature of the information that you may require. But I do not see how the score may not be given. But obviously, if it goes into the personal information, that's where the issue of balancing may become an issue. But those are the issues that we normally leave it to the information officers, and the regulator, depending on the case, will decide whether we should force people to release those information. But the element of accountability and transparency, those are the constitutional value which, as the regulator, we encourage that you need to comply with.
Thank you, Mr. Nemasisi. So the information officer or the deputy information officers are always traversing a tightrope of trying to balance between 2 conflicting interests and 2 conflicting values, that of transparency and accountability and that of privacy. And so, Advocate Weapon, a lot of these difficult questions will end up on your desk. I would really like to hear what your take is on just the questions that have been posed and Mr. Nemasisi's take.
Thank you so much, Mr. Dimba. So yeah, it's quite a difficult one, but as Mr. Nemasisi indicated, I don't think it will depend on the circumstances. Remember, if you look at PAIA from a PAIA angle, and it's quite strange that I'm mentioning it in that way, you might find that when you have discussions on a very close platform, like your EXCO, those could also, to a certain extent, depending on the definition and the context, constitute personal information. So there are various dynamics that you need to take in place. So it's not a one-size-fits-all. But there's also this issue that you also need to be careful if in that specific exco, there's a record that pertains to commercially sensitive information that will automatically be excluded in terms of PAIA. So it depends on what type of discussions and conversations took place. And as Mr. Masisi said, it might be advisable for these bodies to look at a more favorable approach, maybe to categorize the different types of information and then to apply their minds and also to get, a respectful legal opinion as to what types of categories of information will, on a discretionary basis, be allowed, and then what type will not be allowed, and also maybe to also ensure that where you don't or refuse or fail, what would be a rational decision that would support, what would be grounds that would support that specific decision. So I think from that angle, just to complement what Mr. Masisi and yourself are actually deliberating on, but yeah, it's not a one size fits all, and as we know, no right is absolute, and they're also subjected to the right of the promotion of access to Section 36, which in essence is referring to the limitation clause in the Constitution. Thank you.
Indeed, indeed. Thank you, Advocate Weapon. I know that colleagues wanted to know about the nuts and bolts of these obligations we spoke about earlier, but I'd just like to take one more follow-up question on this issue of exemptions. So Juliana is asking Mr. Masisi, if in a circumstance, I'm going to change your question. You had said it might be possible to release a score sheet because it might not have personal information. Not in all instances would that type of information be captured. But what if the disappointed applicant then wants the actual CV of whoever got the job? Does this mean that the information officer will have to do what is called a third-party notification? How would this work?
Definitely, the process then will also follow that if you request information that belongs to a third party, you then use the third-party process. This is where you're going to inform the person whose information is being requested to say, does this person request copies of your CV? Do you grant them? And then if they said no, and then we're going to look as well when you receive, especially when you receive a third-party notice, the most important thing that I would say you need to consider is the public interest provisions to say is the important, how the relevant of that information to you. Also, the information, remember, it's personal information. The private or public body, they have obligation under PAIA that when you receive the personal information, you must protect it. You don't just release it to any person. So those are the other issues that we look at when there's a request for an information which is a personal information or third party, that I provided my CV to company A because I believe that they are compliant with PAIA, and therefore my information will be protected and not be disclosed to anyone. And all of a sudden, the information is being released to somebody else. That may result in breach of PAIA. And we know, I know we're not talking about PAIA today, but you know the consequence of PAIA. If you don't breach any provision of PAIA, you've got a fine of about 10 million. And we don't want to go into that space where it's just releasing a CV and then you end up paying 10 million. So those are the issues that we need to consider when personal information is being required, that you do not just release them. You need to exercise, be careful on whether to release those information or by third-party process is the right way under the PAIA.
Thank you, Mr. Masisi. Thank you, Advocate Weapon. I can speak all day about these meaty questions around how you navigate this tricky area of exemptions. But Mr. Masisi, you've threatened people with prison time just before Christmas. So let's look at those types of issues. Repeal wants to know, are public bodies mandated to submit the Section 15 list of automatically available records to the information regulator?
I have to check. I remember. Sorry.
May I just give you three and you can take them all together? Yes. Yeah. So the first one was on Section 15 lists of automatically available records. Must they be sent to the information regulator? The second one relates to Form 2. Ms. Hobson wants to know if Form 2 should only be used for PAIA access requests, and can it be used for POPIA, or is it just only for PAIA access requests? That's the second question. The third question, I think you've already addressed. It was, Ncedisi wanted to know the deadline for developing PAIA manuals by public and private bodies. So perhaps you can take all three of those at one go.
Okay. Okay, so the first question relates to the voluntary disclosure automatic available information. So if you look at Regulation 5 under the PAIA regulations, it talks about the head of private body may compile and keep a description of categories of record contemplated in Section 2(1) of that are voluntary disclosure automatically available without the requester having to request access therefore. And then said the description contemplated above is compiled and kept. It must be updated as soon as practically possible and made available to the information regulator. That is Regulation 5.2b. So it means that must be made available to the regulator, must also be made available on the website of the private body, and also be available for inspection at the registered head office of a private body concerned. So obviously the requester may request a copy of the records contemplated and must be provided with such a copy upon payment of the fee. So as it's currently in the regulations, they are supposed to be made available to the regulator, those records that are automatically available under Section 52. The other question is with regard to the, you can remind me, Program Director, is it the
Form
exemption?
2. Form 2,
yes. Form 2, it's one of the issues that we looked at. If you look at Section 23 of POPIA, it cross-references us to Section 18 and 53 of PAIA. And the conclusion that we have based on that interpretation is that when you request access to personal information, you'll have to use Form 2. But then when the information, when there is a breach on the access to your personal information, you then use POPIA complaints form to lodge a complaint. Because in terms of POPIA, any breach with regard to the access to the personal information, we call it interference with the processing. And in other words, it means you breach one of the 8 conditions. And once you breach one of the 8 conditions, the complaint is dealt with under the provision of POPIA, wherein the regulators got more power as compared to the PAIA. There under the POPIA, when you lodge a complaint regarding the processing of personal information or access to personal information, the complaint will be lodged using the POPIA form. But when you request access to personal information, you're going to use the Form 2 to request. In other words, when you want to request access to personal information to the body, you use the Form 2, which is the PAIA request form. Either it's a personal information or any information. But if that information that has been refused is a personal information and you believe they fall under POPIA, then you lodge complaints using the POPIA processes.
And then the last one
just to add on that, Mr. Dimba, we are in the process of finalizing our rules of procedure. We're going to detail the process to clarify these processes in the rules of procedure, which will be publicized on our website. We are hopefully that maybe by the end of March next year, we should have the rules of procedure there, where we'll provide detailed clarity as to how do you differentiate between the access to personal information and the general access to information. Thank you.
Sorry, Mr. Timba, just to come in.
Yes, please.
Yes, thank you so much. And this is a very good example that Mr. Ncedisi gave. So when you then refer to the domain of access in terms of POPIA, you'll find them under Section 23, specifically subsection 1 to 5. And those are then referring you, especially from subsection 3 to 5, to the provisions in PAIA. So it then confirms that these two acts, to a certain extent and degree, have interoperability. So they then, a certain extent, need to be together in order to realize some of the rights. Thank you.
Indeed, there are two sides of the same coin. Then there was a question, Mr. Namasisi, regarding the manual, the deadline for developing manuals. It was answered online, but probably we need to emphasize the point.
Unfortunately, we are not going to, there will not be any further exemption as we indicated. By the 31st of December, you need to have your own manual available in terms of in the website or copy in your head office and upon request by the regulator. So that's the requirement, because exemption will not be, there will be no further exemption from the 31st of December 2021. And that's why we developed that template. And I think that it's available in our website. So that template is user-friendly. Within a day, you can actually compile your manual. Obviously, the person who compile manual must be a person who knows the organization. You need to know which records you have. It cannot be a new person who doesn't understand the organization. So a person who knows which information or document you have, that's the person who can actually assist with compiling that manual. It's a very user-friendly that we encourage everybody to go to our website and use that template to populate their PAIA manual.
Thank you, Mr. Namasisi. Advocate Weapon, did you want to add on that point?
No, I'm covered by Mr. Namasisi. Thank you so much.
Thank you. Colleagues, there are so many questions on the chat box. Thank you so much. I'm just afraid that we won't be able to get to all of them. In case that tragedy happens, please note this email address, enquiries@inforegulator.org.za, enquiries@inforegulator.org.za. Please send those questions through, and we'll most definitely respond to them in case we don't get to all of them by the end of this webinar.
Sorry, Mr. Dimba?
Yes,
sorry.
Advocate
Yes.
Weapon.
My apology for interjecting. I would just want to ask if it's possible, there's just one slight issue that I've noted on the chat where a comment was posed that in a province, you find that a DG is the information officer, and then all the HODs are then DIOs, deputy information officers. And I think it then warrants the intervention of Mr. Namasisi in this regard. It's safe to say that each of those entities are juristic or legal yes, on their own. But Mr. Namasisi, can you please just correct the situation so that we don't leave it uncorrected? Sorry for that, Mr. Dimba, and thank you so much.
Not at all, Advocate Weapon. It's an important one, and the issue you're talking about, I have experienced before, where the DG in the office of the Premier is regarded as the information officer, the only information officer in the provincial administration.
Yes.
Mr. Namasisi, can you advise us on this one?
Thank you so much, Advocate Weapon. Thanks, Program Director. Indeed, if you look, actually, the first piece of legislation, you have to look at your PFMA. It indicates who's the accounting officer of a provincial department. And once you are accounting officer, it means you are actually the person who is the information officer. So let's start with in the province, you have got the DG in the office of the Premier. That DG is an accounting officer in the office of the Premier. But each department in the province, those departments, they've got accounting officer, and HODs of each department are information officer, and they must appoint their own deputy information officer. The HOD cannot be a deputy information officer. So the DG is the information office of the Premier, not the information officer of the whole provincial department. No, it doesn't work that way. So each HOD of the department are actually information officer, and they must appoint deputy information officers.
Thank you, Mr. Namasisi.
One of the questions, maybe now that I've got a platform on the appointment of deputy information officer, one of the questions that normally pops in is with regard to if a group of company, so you've got what do you call them? So your holding company, you've got your group of company, you've got other entities under that company. If those entities are legal entities, they're not necessarily department, but they're literally legal entities. In other words, you've got NEMA-CC Holding Group, and then you then have NEMA-CC Pty Limited. That's a legal entity. The CEO of NEMA-CC Pty Limited is an information officer of that Pty Limited. So it means each legal entity must have its own information officer. But you've got instances, for example, if you look at, if I can give a practical example of FNB, they've got West Bank, and actually West Bank, we've just found that it's not actually legal entity, it's like a branch within the First Rand Bank. So in that instance, the First Rand, the CEO of First Rand is the one that would be there, see the account, the information officer or head of private body, and not the managing director of, because that's it would be a division, with not necessarily a legal entity. So that's how you need to differentiate between the two instances in which you're required to have an information officer. So if your sub-entities are actually legal entities with the CIPC, each entity must have its own information officer. And this is literally because you find that these entities do not process personal information the same way. And therefore, the responsibility of information officer of the holding company may not be the same as the information officer of the subsidiary company, because it provides different services and therefore process different personal information. Thank you, Mr. Dimba.
Thank you, Mr. NEMA-CC. Before I hand over to my co-pilot for this program, Ms. Zondi, can we just quickly take one question that came from the floor in terms of Section 32 reports? Are bodies, public bodies, still required to submit the Section 32 report? And is there a reporting template?
Yes, I indicated within the presentation that we do have the reporting template, but what we've decided as the regulator is that we need to streamline our process to be much easier to process them. Even internally, if you submit those statistics manually, it's difficult to compile them and put them together. But we are developing a portal, which would be an online portal where all the information officer of public bodies will go online and compile and fill in those statistics online. And automatically the system will go back into the dashboard. We'll have the complete statistics. So we do have a template that if the system is not functioning, we will submit your office, Mr. Dimba, communication department will distribute those template to the public body for them to be able to start completing those forms. It is compulsory, unlike in the past where Human Rights Commission was not enforcing the compliance with the Section 32 reporting. With the regulator, our mandate is to ensure that we comply with each and every piece of our provision of our legislation. So each public body will be required to submit those statistics. But we are trying to streamline our process on the online platform, which we are hopefully that by 31st of March, that system will be live. But if it's not, the template is already, it's available, it will be distributed by the communication department.
So just to be sure and to be clear, Mr. NEMA-CC, in terms of the 2020-2021 financial year, which ended in March this year, bodies would have had to report to the Human Rights Commission. We don't yet know what happened there. But as for the 2021-2022 financial year, which ends on in March 2022, this is when now public bodies will have to report to the information regulator.
Definitely. So around May, June, we're going to open the system, or if the system is not functioning, we're going to distribute the forms which they need to submit the statistics for 2021-2022 financial year. Definitely.
Fantastic. Let me hand over to Mr. Zondi, who will lead this segment. Thank you.
Thank you so much, Mr. Dimba. Thank you, Mr. NEMA-CC and Advocate Whippen. I know that was quite a information overload, but there are a lot of questions that are in the chat box, but I think I'm going to commit PAIA division as well as education and communication division that we will publish the question and answers that we may not be able to reach today, because there are quite some good questions that are coming through which require our responses. But because we are about access to information and we live by it, I think I'm going to allow for a few questions to be posed verbally from the participants. I do see Julian Kruger has eagerly been waiting with their hand up to ask a question. So I'm just going to allow for a few hands to come up, and then I'll identify you and allow you to speak. Julian, please can you, I'll ask you to go first, then you will be followed by Charles to pose your question.
Thank you, ma'am. Ma'am, my question related to the issue of the information officer in the province, in the Eastern Cape, for instance. If one looks at the appointment of heads of departments, that is done in terms of the Public Service Act. Now, if you look at the PAIA and you read the legislation, it refers to in terms of the columns, it refers to provincial, or it refers to in the province, the provincial administration, the provincial administration, and not the provincial department. So I'm still a bit confused, because if I look at the columns under the Public Service Act, where it says that in the department, I mean, in the province of the Eastern Cape, the DG is then regarded as the head of that provincial administration. So whilst the Act refers to administration and not head of department as information officer, I think there is a need then for that clarity, or the legislation that refers to the provincial administration needs to be amended. Otherwise, when you read the different pieces of legislation, then definitely our view is that it refers to the DG in the office of the Premier. And here we're not talking about the PFMA, we're talking about the appointment of heads of department in terms of the Public Service Act. Can I get just a response to that?
Okay, thank you so much, Mr. Kruger, for your question. I will, before Mr. Nemasisi and Advocate Weapon or Mr. Dimba comes in, can I just take Charles, and then I will close off with Moloko after Charles. Charles, over to you.
Yeah, thank you, Program Director. With respect to education, you'll understand that in terms of the South African Schools Act, schools are a juristic person. And then the question is its principals, automatically information officer. The dilemma is that you'll understand that principals are actually representing, are employees of provincial education department. So the question is whether principals, because schools are juristic person, are automatically information officer. Thank you.
Thank you, Charles. Mr. Nemasisi, would you be comfortable for me to just take the last question that I have from Moloko, or would you like to respond to those quite detailed questions before we move to Moloko?
Moloko can ask a question.
Yes.
All right.
I would just like to come in there if
Okay.
after Mr. Nemasisi, yes.
Okay, Moloko, please, you have the floor, and then we will hand over to the panel members to respond to Julian, Charles, and Moloko. Thank you.
Thank you, Chairperson. I think my question is, actually it's not a question per se, it's just a comment that I want to make. The presentation from Mr. Nemasisi is superb and wonderful. However, what I'm just suggesting is that since this presentation, I'm calling from the Limpopo Department of Agriculture, but I'm of the view that maybe what would also help much in terms of implementing these two pieces of legislation, it's if we would have a thorough training in terms of implementing the two acts, the POPIA and the PAIA, and the integrations, because that is key for everybody to be on board, more especially if the training can target the DIOs and the IOs, so that we don't have a problem in terms of implementing these two pieces of legislation. Thank you so much.
Thank you very much, Moloko. I think your last question, or your question in main, will be responded to by Mr. Dimba. But I'll just hand over now to Mr. Nemasisi, Advocate Weapon, and then followed by Mr. Dimba. Thank you.
Thank you, Ms. Zondi. To answer the first question about the reference to the administration, provincial administration, the provincial administration has got different departments. You've got national administration, you've got provincial administration. The national, the provincial administration has got different departments, and the heads of the department are accounting officers. Those are people who are accountable to that particular department. We have clarified this in our guidance note on information officer and deputy information officer. It is available in our website. If you look at paragraph 5 of that guidance note, we said who should be registered as an information officer. And we specify that the nature of a body, you're going to have public body, and we indicate who are those public bodies. We said national department and provincial department. In terms of the national department as an administration, you've got DGs, and then national department, and then provincial governance components. It's a DG as well. But then you then have the presidency, it's a DG in the office of the presidency. You have got a provincial department. And that's where you then have the heads of the department. Those are the information officers. If you can go into our guidance note, you'll see we provided guidance on that respect. We were aware when we developed this guidance note about the confusion. And this guidance note was intended to provide clarity as to how do you then interpret who is the information officer in terms of the provinces. And so in other words, when you look at the element of accountability, we cannot disregard PFMA as the main legislation that indicate to us who is the accounting officer. So any person who's an accounting officer is by nature that person, the one who's supposed to be an information officer, because remember, accounting officer is not only with regard, you don't account financial only, you account even for the processes under that administration. In other words, if there's a process, you're processing, you are the one who signed the tender document. Why would you go to somebody else who did not sign the tender document when the request for access come into your offices? So that's why the element of accountability is linked with who's supposed to be the information officer. We would like to refer you in this respect to the guidance note. It actually details the processes of who's supposed to be considered as an information officer. The next question is with regard to the principal. Similar process happened. The principal of the school is actually an information officer. I've seen a lot of schools registering their information officer. And this is because these are the people who actually oversee the processing of personal information. When kids are being admitted in those schools, the principal is the one who oversees and ensure that all the records and all the information that's being processed, they ensure that those records are supposed to be kept safe at each school. And those are the principals that are the ones who are supposed to, if you want access to the information, for example, while your kids are not admitted, the DG of the provincial office or national office may not even know, because the admission is done by those schools, not necessarily, except for those that are actually in Gauteng, wherein the provincial office are responsible for, especially, I think it's grade 6 or grade 8. And yeah, so those ones are the ones that the provincial office might be responsible. But in respect of other aspects, the accounting person will be that the principals. And I think the one for training, Mr. Dimba will deal with it. Back to you, Program Director.
Thank you, Program Director. Let me just come in there, Mr. Nemasisi. Thank you so much. Yeah. So you're quite correct, Mr. Nemasisi, and it's also for us to provide maybe a separate webinar, Mr. Dimba, Mr. Mzondi, and focusing on what we would now call the guidance note on information officers and deputy information officers. What is also very important to understand, and the section that Mr. Nemasisi referred to, Mr. Kruger, is section 38 of the PFMA, which then spells out the accountabilities of an information officer in terms of that specific accounting officer, which is, for all intents and purposes, the HOD. So what is also very important to appreciate is that these departments that you find are established in terms of a different legislation. The Department of Health will have its own founding legislation as opposed to the Department of Social Development in the Eastern Cape. What is also very important to appreciate is that if you look at the Department of Health, for instance, it is so complex and it is so big. So hence, the number of, apart from the issue of the information officer who's actually the HOD, but also the fact that you might now have more deputy information officers because of the purpose of access in the different districts in the Eastern Cape, as opposed to a smaller type of department that doesn't process as much personal information as that specific department. What is also very important to appreciate about it, when coming to the schools, for instance, is the fact that you don't find in Gauteng only public schools where the principal is then reporting to the provincial the authority for the Department of Education, 111 Commissioner Street for Gauteng. But what is also very important to appreciate in this respect is that there are also private schools. So those private schools might not belong to the Curo group. You find different private schools. So for that intents and purpose, each of those private schools are also considered a legal entity on their own. Like the Curo group, and as Mr. Nemasisi said, you find one in Senton, you'll find one in Honeydew, but the issue there is that each of those schools are registered separately and they become a legal entity despite them having a group. And that specific principal will then be that specific person who's then responsible and accountable for all intents and purposes, and then is automatically the accounting officer, or can also be viewed as not only the accounting officer, but the information officer of that specific school. But we need to have a more detailed discussion in this. And then lastly, Ms. Zondi, it's just the issue which we have not touched on of an authorized information officer, and that's now a different spin to the whole discussion, which I'm actually now asking that maybe in future we should consider just going back into our guidance note and also then making more practical examples and then furthering the discussion that we currently having. Thank you.
Thank you, Advocate Weapon. It's very clear in our discussion that there are nuts and bolts that we still need to deal with in terms of the questions that are being asked. And thank you for clarifying the issue of the education sector, because we have been getting a lot of inquiries in terms of who then becomes the information officer. As we draw to the close of this program, I do see Nicolette Brand, who I want to do justice to a question. She says that, can we please answer the question regarding the requirements to the Gazette, the Section 15 list? Unfortunately, Nicolette, I wish you could raise your hand so you can clarify that question for us, because we're unable to navigate the chat group to find that question. But whilst you are raising your hand, I just want to take one last question in the chat group, Advocate Weapon and Mr. Nemasisi. I think it comes from Peter van der Waals. He says that there are approximately 10 legal entities, but they only have one website and they deal with all PAIA requests centrally on behalf of all these legal entities. So he then asks, do they have to have a separate manual for each entity as they only change in each, or should they have their own manuals for the companies? I think we did respond to a similar question, but maybe because I see there's a number of those questions related to that of Peter's, maybe let's just provide some clarity in this regard, Advocate Weapon or Mr. Nemasisi. Thank you.
Okay, I'll start. Member Point, you want to start?
No, Mr. Nemasisi, just wanted to hand over to you, sir. Thank you.
Okay, thank you so much. Okay, I tried to answer this question earlier on to say, if you have a group of companies and you have subsidiaries, which are also legal entities, so that those legal entities, they've got different processes. So you find that entity one deals with other things, entity two deals with other things. So it means the records that you have are not the same. And therefore, each entity should have its own manual. because you might find that the people who want access to entity B or subsidiary B are actually those who are dealing with them only. And you want to have a manual that deals with the records of that particular entity, because manual, although you may have, there might be subsidiary entities, obviously the records that they keep may not actually be the same, because they process information differently. And therefore, each legal entity must have its own manual. With regard to the requirement of a website, whether if you've got one website and all these entities are in one website, the requirement, and indicated during my presentation, of putting a manual in the website, it's not an obligation, it's if any. So if you don't have a website, does not mean that you are not compliant. You can actually have that manual at your reception, because when they say head office, it means when a person comes and say, can I see your manual? It must be at the reception for that person to be able to see those who approach your offices. So the requirement of having the manual in the website, it's if you've got a manual, because the legislature were aware that not everybody can afford to have a website. So if you do have a website, then it means your website must have the manual. But if you don't have a website, you're not actually obligated to go and incur costs to have a website in order for you to have a manual on the website. So, but it's in summary, if it's an entity, that entity, legal entity, that entity must actually have its own manual, because the processing and the records are not actually the same.
Thank you, Mr. Nemesis. I think we're definitely going to put that in our frequently asked questions, so to assist group companies. Nicolette, let me allow you, and you are going to be our last speaker for today. Thank you.
Thank you. Can you hear me?
Yes,
Hello,
you're audible. Go ahead.
Thank you very much. Thank you for the opportunity. Currently, it's a requirement according to section 15.2 1B to gazette your list of automatic available records. I just wanted to know if that is still a requirement, or if it's fine just to send it to the information regulator. Thank you. That was my question, and that was also the question of Ms. Busisiwe Onanda. So thank you for answering that.
Thank you, Nicolette. Over to you, Mr. Nemasisi. Please unmute yourself, Mr. Nemasisi.
Just verify the requirement. I know in the regulations, you do not have to gazette it. If you look at regulation 5, as I indicated earlier on, so for public bodies, regulation 4, with regard to those automatic available records, which deals with the section 15.1A and B. And then for regulation for private bodies, is regulation 5. It does not talk about the gazetting. It talks about putting it, making available the information regulator in the website, and also available like the PAIA manual at your head office. I just have to check if that section 52, you said 52, is it 52 AB? I'm not sure. I need to verify if that has been amended. You might have to check at the amended legislation whether that section may have been amended. I remember when we were drafting the regulations, we tried to lift a lot of burden on the public and private bodies insofar as gazetting is concerned. But I'll just have to verify, can this be one of those questions that we will attend to them at the later stage? I'll just have to verify in terms of the amended legislation whether there's a requirement for gazetting. But the main answer, if you go to regulation 5 and regulation 4, you'll see that we do not talk about there's no requirement for gazetting. It's just to, in your website, submit to the regulator as well as making available at the head office.
Thank you so much, Mr. Nemasisi. And that brings us actually to the end of this webinar. Thank you so much for all the participants for joining us on this auspicious day, the 10th of December, where we actually commemorate or take note of International Day for Human Rights. And the turnout on our webinar was quite outstanding merely because it's even a Friday. But I think what I want to promise the participants today is that we will have this webinar posted on our website. We will respond to the questions and also publish those on our website. But as Mr. Nemasisi and even Mr. Dimba kept reiterating and calling for public and private bodies to send their inquiries to us using our email address, inquiries@inforegulator.org.za. I would like to thank Advocate Weapon for being part of this session as well, where he did highlight the importance of this day. And he did commit that the members of the regulator will place a keen eye on ensuring that this right PAIA is realized. Obviously, he touched on the issue of in relation to compliance by public and private bodies, carrying out the complaints and investigation when the access is denied to information, but also creating awareness, particularly to the previously disadvantaged communities. I think we also did mention the fact that we place emphasis on the changing landscape of PAIA. Often one of our members, Ms. Tilly, will say that there is a need for an update in PAIA because of the evolving environment and for the fact that it was developed during the times of fax machines. And Mr. Dimba did reiterate that we need people and stakeholders to assist us to navigate PAIA. So it's very important for us to note that PAIA in itself, there was a notice that was issued that there is an extension till the 31st of December. Mr. Nemasisi has emphasized a lot that post the 31st of December, you should have your PAIA manuals in place. So it's important to understand that PAIA manuals are a roadmap to help us facilitate the exercise of right to access to information. So in way of summation, Mr. Nemasisi outlined the key objectives of PAIA, the application provisions. He also spoke about the availability of PAIA guides, where he indicated that we have to ensure that our PAIA manuals are developed and they are published. There is no exemption for public bodies in terms of compiling their PAIA manuals, and they have to ensure that those are available in at least 3 official languages. But it's also important to note that private bodies have the same obligation and they need to develop them at least in the language, the main language or the official language being English. I think what I also like to just highlight that Mr. Nemasisi also emphasized is that there would be sanctions that may be imposed should we not adhere to making making the PAIA's manuals available. And it's also advisable that we do appoint deputy information officers so they assist in supporting the IO should there be requests for access to information. We do not, we indicated that there is no limit in you appointing deputy information officers, so you can use your own discretion depending on the size of your organization. He highlighted the grounds for refusal of access to record, lodging a complaint with the regulator, but also highlighted our investigation powers as the regulator. So I think we have tried a lot to assist public and private bodies in terms of ensuring that we comply with PAIA. We're obviously going to conduct further training sessions and stakeholder engagements on PAIA, but we do invite all public and private bodies to make use of our website, www.inforegulator.org.za. And you can find there the PAIA regulations, various PAIA forms, and as well as the guidance notes that we have developed as the regulator. So once again, I want to thank Advocate Weapon, Mr. Nemasisi and his team, the Education and Communication Division led by the earlier pilot, Mr. Dimba. But mostly we like to thank you for your participation. And I'd like to just say, keep a lookout for more information sharing sessions that the regulator will host. We always publish this on our website as well as our social media pages, our Twitter and our Facebook page. Our Facebook page is Information Regulator SA, and our Twitter handle is @InfoRegulatorSA. So we will make all of this available to you on our website. Thank you very much. And this is the end of our webinar. Have a good afternoon and enjoy your weekend.
Bye, everyone.
Thank you, everyone. Just bye.